Good afternoon. I'm Catherine Restrepo, and I'm the Executive Director of the Master in Law program at the University of Pennsylvania Cary Law School. Along with my colleagues, Natalie Green and Kate Johnstone, and our panel of distinguished experts, we welcome you and we thank you for joining us at today's event, which is sponsored by the Master in Law program. We bring you events like today for several reasons. First, to highlight the law's impact and intersectionality in all of our lives, which enables us to highlight a key principle of the Master in Law program, which is that law belongs to all of us, and that legal education should not be reserved exclusively to those who choose their careers as lawyers. Rather, those from across industries benefit tremendously when they educate themselves in the law generally and in the law of their fields. One of our panelists today, Dr. Lee Fleisher, demonstrates this point beautifully. While a student in the program, he was practicing and teaching medicine and chairing the Department of Anesthesiology and Critical Care at the university when he was approached to become the Chief Medical Officer of CMS. Dr. Fleisher reports that daily he draws on the lessons learned in the program and specifically in the regulatory state class to help inform his work in this vital role at this critical time as we face this pandemic. We also bring you events like today so that we can highlight our program and showcase our program for the audience and members of your extended network. Since 2014, we've welcomed into the law school and educated a tremendously diverse group of industry leaders, emerging and established professionals, academics, and students across industries, enabling them to further enrich their careers and their work, better understand and inform their work, and to create value in their careers and to bring value to those they serve. We should get on to today's program. I have a few housekeeping items. For those of you in our audience, I understand we have just under 200 members of the audience. Thank you again for joining us. For those of you seeking CLE credit, you will note CLE codes will be presented in the form of a poll. I'm able to give you our first code, which is Blizzard. Please write those down. You'll be required to enter those into a form, into an evaluation form after today's event. Many physicians and medical professionals are with us today as well, and thank you for joining us. Those who've chosen to receive CME for today's event, you will receive an email after today's event with instructions on how to claim that credit. I'd like to introduce our panelists today. I am humbled and I am unspeakably grateful for their participation in today's event and their time and dedication in preparing to bring you this very important discussion today. Leading our discussion today and moderating is Professor Allison Hoffman, an expert in her own right in the matters in which she teaches and publishes prolifically and speaks, and that is health law and policy, the regulation of health insurance, Medicare, the Affordable Care Act, and many related industries. Joining our program, we're delighted to have Professor Cary Coglianese on the call as well, the authority in regulatory process and administrative law. Professor Coglianese teaches both law and political science at Penn, and he directs Penn's program on regulation. In addition to Dean Ruger, who's also serving on today's panel, Professor Coglianese helped inform and design our Master in Law program, and especially that vital part of the degree, which is administrative law and regulatory process. Dean Ruger, in addition to time spent in his day job, which is running this fine institution, he's also a health law and constitutional expert, and somehow he manages to find time to teach constitution law to our Master in Law students. In fact, Dr. Fleisher was in his class, I recall. And finally, as I mentioned, Dr. Fleisher rounds out today's panel. We're absolutely delighted. As I mentioned, he is currently a professor in Penn School of Medicine, teaching anesthesiology and medicine, and he also serves as the Chief Medical Officer of CMS. I can't thank our panel enough for all that you're doing, and thanks also to our audience members for joining us today. think at that point, Allison, I'll hand over to you. Thank you.
Thank you, Kathy. Well, it's a pleasure to be here today and with such an amazing panel. And I would love to get us kicked off. But before I do so, let me just do one quick housekeeping measure, which is that we'll talk for about 25, 30 minutes. The four of us, I'll pose questions to each of the panelists today. And they'll have the chance to talk uninterrupted for a period of time to give you a little bit of a sense of their expertise on these issues. And then after those brief introductions and maybe a couple of follow-up questions from me, I'll turn it over to you all, to the audience, to be able to ask some questions today. So the way to pose your questions is in the Q&A function in Zoom. I'm sure you all have done this many times by now, but you just go to Q&A and you could type in your questions and we'll be able to see them there, and I'll pull them up as we go. So welcome, everyone. And let me start off by drawing Lee into the conversation. Lee, you are our esteemed guest today, and a dear colleague of mine at Penn. And what I would love to do is just start a little bit biographically with you. You were chair of anesthesia here at Penn, on faculty in medicine, and then pivoted from there to be the chief medical officer at CMS. Can you talk a little bit about how that process happened? How were you recruited? What made you interested in that job? And then also, as a second part of that question, if you could talk a little bit, you were halfway through or partway through the ML program at the time you entered the job. Can you talk a little bit about how your time in the ML program has related to and has helped you in that role as well?
Thank you, Allison. And you're right, Dean Ruger was my teacher for constitutional law, which I think was the first class I took. So chairs at Penn have term limits, just like deans. And I was in my third term, which would be the ultimate limit, and about a year away, and it was about 2 years away, when I saw the degree program and said, I am thinking about doing a sabbatical at CMS. And I'm thinking about going in and working, maybe designing some of the new value-based programs. It would be really helpful to understand the law, particularly the regulatory state. So I started with Dean Ruger's. It was a great class, continued on to the regulatory state. COVID hits. I still remember about March 10th, coming back from a meeting with colleagues in New York, standing up our task force, and starting as the chair of anesthesia, I also oversaw 6 ICUs. So being fully engaged with the COVID pandemic. And then right before that it hit, I actually have 2 jobs at CMS. I'm both the chief medical officer, which is a job of influence, but CMS stands for the Centers for Medicare and Medicaid Services. So that one of the centers is the Center for Clinical Standards and Quality, which oversees the regs. It oversees the 15,000 nursing homes, the Joint Commission, quality metrics. And so it's got about a $2 billion budget with 875 people. And the person in that role had stepped down. And COVID hits. They start this, to be honest, they start the search for my successor. And I get a call from CMS to say, both my predecessor and my predecessor's predecessor had told the administrator I was one of the few people who should come in, given my interest in coming in as a sabbatical. So we started the recruitment in April. In the beginning of June, I was offered the job. Seema Verma, who's my boss, said that I could do it on leave from Penn, and Penn said I could do it on leave from Penn. And the exciting part about my job is I'm the highest policy person in the agency whose career, which means that in the transition, I still am a center director while every other center director steps down. So I wanted to, before I forget, make clear today, I'm here as a professor at Penn, and therefore anything I say, and this is the usual disclosure, reflects my own opinion and not those of any agency or the federal government for whom I work for. And that in fact, it is fully informed by what I've been doing. And the real key, and I look forward to Cary sort of explaining it, is my group writes regs all the time. I'm in the middle of rulemaking right now. I learned that I'm not allowed to speak to anyone, so I'm learning CMS speak, that I can only be in listening mode between a proposed notice for proposed rulemaking and an NPRM versus a final rule. Within 3 days of me getting there, we were putting out an interim final rule, which Cary, I'm sure, can explain to the group what that means. So, and I put out guidances almost, in fact, one that you teased me about, somewhere between teasing and harassing, of when are we going to let nursing home residents have visitors again. Those were in sub-regulatory guidance. So understanding what I'm allowed to do and what I can't, since I also oversee survey, was how I used the information. It became real to me as opposed to this theoretical. In fact, I grabbed the book off the shelf shortly after I got there to read, did I really understand this correctly? So I'll stop there.
Maybe I'll ask you one follow-up because
Yeah.
you were talking about kind of where, you have been in the administration in a really dramatic moment in time. You stepped into your role in the middle of a pandemic, and now you're in the process of transitioning to a new administration. Can you talk a little bit about what your role is in that process and what that process feels like from the inside?
So there's something called landing teams. So Biden's group, there is no administrator proposed yet. There are 6 people who were chosen by the Biden administration to land at the agency and find out everything they can during the period after certification, but before the inauguration. So they come in and ask questions of the transition team. Being the senior career policy person, but not the administrator, because there's somebody with longer longevity would be the acting administrator at noon until there's a new administrator approved by the Senate, that since it's a Senate confirmation for the administrator, that we have a team of about 14 of us who talk every week. And the landing team I was just meeting, and up until recently, we were only allowed to tell them public information, which you would think they would know, but it's really hard to aggregate in total because it's all over the place, about nursing homes, about my center, about our work with the CDC. And now we're allowed, with certain confidentiality agreements, to provide them with verbal, but I still can't tell them what the final rules will be. I can only tell them what we're working on, but not what we will hopefully finalize.
I'm sure just the process of highlighting, even if it's public information, highlighting certain public information for them and not others gives them a sign of kind of what's moving, what's important at the moment in time. But it is interesting to hear kind of as that transition is made in a gingerly way, that there's a lot of kind of bumpers on what exactly can happen and what can't.
And they actually say to me, so how quickly could we get guidance or rules out the day we come on, starting on noon on January 20th, when they tell us what to do. So it's a really interesting, and they sort of foreshadow directions they may want to go to the career staff.
Yeah, that's very interesting as well. So I want to pivot to Cary and draw him into the conversation as well. You were promising that he would elucidate the regulatory process for us a little bit, which he is, he's one of the leading experts in the country on this process. He could probably speak from now until next year, maybe the year after, about it. But Cary, could you just talk a little bit about some of what that process looks like, especially at a moment in crisis? So what are the limits on federal rulemaking that come into play and that can be impediments to make it difficult to regulate in a moment in time like this one? I'm sure Lee has experienced many of these, but can you talk about it from kind of the legal structure as well? And I think you're muted, so make sure you unmute before you jump in.
Well, thank you very much, Allison. The great question. And I want to actually also offer my thanks to Lee for not only joining us here today, but also for committing to the round of public service that you're engaged in right now for the country. And I I think it's related to what I want to say, that on the one hand, Dr. Fleisher is a world-class expert with incredible knowledge in medicine, healthcare policy, and management, and yet he goes off to government to apply that knowledge. And what he needs to know are things like he was saying, how do we put out a guidance, or how do we issue a rule? He needs to know, in other words, about the process. And I guess that's what I really want to emphasize, is that the process is vital. You can know the right policy decision to make, but if you can't effectuate that in a lawful manner, it's not going to help much. And I think in a pandemic, this is particularly crucial. We have seen, litigation occurring, particularly in the news. We see this at the state level, where there's been lawsuits challenging governors' authorities to impose public health restrictions. But even at the federal level, agencies are needing to make innumerable decisions. I mean, the FDA makes decisions about testing protocols, treatment and various vaccines now, and CMS about various nursing home standards, as Lee was mentioning. The process is what's going to make those real and make those stick. And I think, it's not clear that this current White House always appreciates that, the importance of process, because when process gets short-circuited, or when it seems to be tainted with politics, or even appearing to be so tainted, like when you call an FDA administrator to the White House to talk about vaccines, failure to follow the process can undermine public confidence, and it can create real legal problems for the agency. So I do want to talk about the process of the kind that Dr. Fleischer mentioned and has surely come to appreciate very well in these times, the rulemaking process. I'll say a few words about what rulemaking entails and when agencies have to go through it. I'm specifically going to talk with in mind a Supreme Court decision from last year involving the process for creating Medicare rules, a decision called Azar versus Alina Health Services. But before I turn to the Alina case, let me offer at least some background basics. A lot of what all agencies do at the federal level is issue rules. We think about in our high school civics framework that there's just 3 branches of government, and Congress makes the laws, and the president and the executive branch administers the laws, and the judiciary settles disputes involving the law and interprets what the laws say. That's the high school civics picture, but the reality is that when it comes to making law, regulatory agencies, administrative agencies like CMS, like the FDA, and so forth, are making most law today, at least by volume, approximately 4,000 rules in a given year, 3,000 to 4,000. And that's been true, by the way, even throughout the last 4 years in an administration that claims to be highly deregulatory. There's still a lot of rules that are being made. And the normal process for creating a rule is typically governed by the Administrative Procedure Act, or the APA. And that requires that agencies provide and publish a notice of proposed rulemaking, an NPRM, then invite public comment on that notice of proposed rulemaking. And then the agency is supposed to read all those comments, digest them, and then they can issue the final rule, maybe making modifications based upon the comments that came in. That is a process that has been used extensively since the 1970s. It was authorized initially in the 1940s, but really has picked up since the 1970s and is now considered by what one administrative law scholar has called the greatest invention of modern government, because it, in principle, allows agencies to work quickly, notice, comment, final rule. But the reality is that as maybe great of an invention as it might be, it can be more cumbersome than it sounds when you just say notice, comment, final rule. I mean, for one thing, if the comments lead to some kind of unforeseeable change in the proposed rule, then the agency has to publish another notice about what they would call a supplemental notice of proposed rulemaking to explain why they think they're going to change direction. But there's also additional requirements for rulemaking that are layered onto those of the APA. There's executive orders that require White House review of regulations that rise above a certain significance level, either in terms of their economic impacts or their impacts on the budget. There's a variety of other statutes that might come into play as well, the Paperwork Reduction Act, the Regulatory Flexibility Act. And ultimately, at the end of the day, once an agency issues a final rule, there's the prospect that somebody can take the agency to court and seek judicial review of that rule for compliance with the statute, authorizing the rules, compliance with procedures, and accord with an overall test of rationality under what's called the arbitrary and capricious test. And as a result, what was once thought of as the greatest invention of modern government by some administrative law scholars is now called by other administrative law scholars an ossified process. It takes time to go through the steps needed to put forward a rule in a way that will withstand judicial review. Now that's the general picture, but it turns out, in fact, that about half of all rules across the whole federal government get issued without going through the notice and comment process. And that's important for agencies because, as I said, notice and comment, can take some extra steps. If the agency wants to put out some information right away, maybe articulate some best practices, if it can do so without going through that notice and comment process, it would be a lot faster and maybe in some cases much more effective too. So there are some ways that agencies can get around the notice and comment process. There's first of all an exemption for good cause, and that's the term in the Administrative Procedure Act. It applies in emergencies. Pandemics might give a lot of opportunities for agencies to invoke the good cause exemption and allow the agency to escape from having to undertake notice and comment. There's also another exception for what are called in the administrative law world, non-legislative rules. Often they're just referred to as guidance. They provide some clarity about what the law means, but they're not supposed to themselves be making new law or creating new binding obligations on members of the public. And guidance, again, can be really helpful for getting information out about current protocols quickly. Yeah. Now, what's the difference between guidance and rules turns out to be a really important issue then, because guidance doesn't need to go through notice and comment, but rules do. Now, lots of administrative law scholars have spilled a lot of ink about the difference, and because it's not always clear. Now, you can commonsensically identify some clear cases of guidance. If you think about when you have ever done your tax returns and there's some instructions on an IRS pamphlet or on the IRS website about how to fill out your tax reforms or what counts as a legitimate business expense. If it's on that website, it might not be just what's in the binding law. That's guidance. That's an easy case. But the law books are actually filled with many, many cases that try to figure out whether something is guidance or whether it would be what would be called a legislative or substantive rule. And it turns out that this exception for guidance is central to the Supreme Court's decision in the Alina case involving Medicare rulemaking. But there's also one other final exception that I think is worth noting, because notice and comment under the APA also doesn't apply to rules that relate to budgetary matters. And that's basically what a lot of Medicare rules are indeed about. So Medicare rules had for many, many years not had to go through notice and comment. But, and I teach my students that there isn't such a thing as administrative law singular, there's administrative laws plural. Congress stepped in the 1980s and amended the Medicare statute to say that even though budget rules, a lot of Medicare rules would not need to go through notice and comment because of the APA, we're going to override the APA and say that any rule or even guidance that, quote, establishes or changes a substantive legal standard affecting payment for services, close quote, does not need to go, does need to go through notice and comment. And that's where the Supreme Court's decision in Alina really comes in. Specifically, this language in the Medicare statute requiring notice and comment for anything, whether it would typically be called under the APA a rule or typically be called under the APA guidance, no matter what, if it establishes or changes a, quote, substantive legal standard, it has to go through notice and comment. And that language is interesting because it's not language found anywhere else in the United States Code. So it's substantive legal standard is just in the Medicare statute, but it's very similar to what the APA calls a substantive rule, which must go through the notice and comment process too, but non-substantive rules under the APA don't have to. The question before the court in the Alina case was really whether the substantive legal standard in the Medicare Act, that language, is the same as substantive rule in the APA. And the court, in a 7-1 decision last June of 2019, held that they mean different things. This means that but what does it mean? It means sometimes when the CMS might want to issue guidance, if that guidance is establishing or changing a substantive legal standard in the Medicare Act term lingo, CMS might have to do notice and comment, even though if it weren't for the Medicare statute and just the APA would not require it. In other words, a guidance at CMS now, if it establishes or changes a substantive legal standard, will need to go through notice and comment and not be able to be issued as quickly and expeditiously as one would ordinarily be able to do just under the APA. Now, the real wrinkle, and I suspect maybe the source of a lot of heartburn within CMS, is that while the court said that substantive legal standard is not the same as a substantive rule in the APA, it never defined what is a substantive legal standard. It just basically said all that case law that's developed under the APA about what is a substantive rule, well, that no longer really applies. The agency, in other words, I think is now finding itself in uncharted territory and trying to figure out, when do I need to go through notice and comment and when do I know? And that kind of uncertainty for CMS comes at a time, it seems to me, that's quite unfortunate, because certainty would be, I think, very valuable today as we need to move quickly, as we might, as an agency would need to issue guidance quickly. It would be helpful in a pandemic to know a little bit more clearly whether the statute under the Medicare statute requires notice and comment or it doesn't. But I do think, to return to my earlier point, that this all emphasizes that figuring out the process really matters. Part of the government's job in a pandemic or in normal times is, of course, to get the right policy decision made. But the other part is to know how to actually make that decision. And that's why, I guess in the end, if we're going to bring this back to our Master of Laws program, we have a required course called Navigating the regulatory state. Thank you.
Okay, that was super helpful and interesting to be reminded of kind of how complex that picture is. And Lee, I would love to draw you back in for a moment because as Cary was talking, I had two questions for you. One is, who knows about this? I mean, I imagine many people graduate law school today and don't know enough about this process and how exactly it works and where the boundaries are. And it changes, right? It shifts with new cases like Alina. So when you stepped in on day one, was there somebody who advised you on on kind of what the appropriate administrative process was, or where there were gray areas? And did you feel constrained by that? Did it sometimes feel like you couldn't get done what you needed to get done?
So we write a reg, which goes to me to approve, which goes to the administrator to approve, which goes to the deputy secretary to approve. At the same time, it goes to the Office of General Counsel to say, did we or did we not violate Alina? And even if we write a guidance, it goes to the General Secretary. It goes to the Office of Management and Budget, where Cary mentioned the Paperwork Burden Reduction Act, which I got a whole lecture on last week from OMB. It may go to the executive office. So we talk about, and when I go to the OR, they laughed. I say, I'm going to have to disappear for a while because I have a call with the White House. Well, that's OMB or EOP, the Executive Office of the President, because they weigh in. So it's General Counsel not. And I'll give you two quick examples, if I may. So we have a rule that says that we can collect certain data from our hospitals, and they have to give it to HHS. Well, they forgot to include the flu. Whether or not we could get data on the PPE and a number of things that Dr. Birx, I'm sure everyone knows from the task force, wanted. We put it in a rule. It came out as an interim final rule, which is the emergency rule path that Cary mentioned. But then she said, oh, I want to know the flu. And OGC said, that's really not allowed under your previous reg. So on Friday night, I got a call that the OMB decided we must have this, because they got a call from the task force. And we were having a rule coming out on last Monday. So this is 10 days ago. It came out on Wednesday, but we had to do inside a final rule, an interim final rule, to include new information. And then on your favorite topic, our guidance for nursing homes. So the question is, we said you must do nursing home visitation. And you wrote about it, others have written about it. Well, it's not a rule, it's a guidance. So if a state says we're not going to follow your guidance, i.e. constitutional law, who preempts? If it's in a rule, maybe we could have preempted. But if it's a guidance, what does the Constitution say? And I'll stop there.
So as you were putting out throughout the pandemic, people may not be aware, but CMS put out several times guidance on nursing homes. And it included things like on the visitation issue, if the caseloads look like X, here's what you are required to do in terms of guidance. But you're saying it had no teeth. Essentially, what you were doing had no teeth. It had no enforcement authority, or it might not have.
If they wanted to be, they couldn't go too far because we have the rights of residents under our rules.
Right.
But if they wanted to go less far, that they actually wanted to let everybody in, our guidance could be superseded by the state.
So if they weren't allowing guidance at all under conditions that were presumably safe, you could reach back to that earlier rule and say, this is within the bounds of a nursing home resident's rights.
Right.
And enforce it based on that, right?
Yeah.
But there were limits.
We had to find what's the regulatory basis for our guidance.
It's very interesting. So I think we should come back at some point again to nursing homes. It is one of my favorite topics and is one that is really important right now. But I want to invite Ted to talk about another constraint on government action and regulation in a crisis and generally, which is federalism. And can you talk a little bit about, this is an area of your expertise as a constitutional law scholar, can you talk a little bit about the way that power is shared between the federal government and the states and how that affects response in a crisis? I mean, we're learning new boundaries now, right? The Supreme Court just enunciated a new limit, when religious liberties come into conflict with a state's regulatory attempts. Can you talk a little bit about both that division between state and federal and where the limits on each are?
Sure, I'm happy to, and thank you, and glad to see such a good audience of, I think, alumni from, I see JD alumni, I see Master in Law alumni, LLM alumni, and as well as faculty and staff and friends. And it's a great testament to the intersection of legal expertise and medical and health expertise, the discussion we're having. And I do, to amplify something that was in the chat, I'll try to be brief, and then we would love to take the audience's questions and that. But I mean, as I was listening to Lee and Cary talk, I mean, in a sense, the theme that I will continue with is by design, making law and policy in this country is difficult. And that's kind of a very, historical, up through the 20th century, I would call it a libertarian impulse, not with a capital L, like you're a card-carrying libertarian, if there is such a thing. This could be Democrats, Republicans, et cetera, but a sort of distrust of government authority. And so we would say, well, we don't want to give all the power to a single entity. We certainly don't want to give it to a single person to then trample on people's rights. And that sounds good, right? Well, it's a terrible way to respond in a fast-moving pandemic. And I'm not arguing for revisiting the system. I guess what I'm saying is, and I guess I say this, Dr. Fleisher is not able to take a position on the administration he's in now and the next one, which he'll also be in. It's a non-political position he's in, but I won't invoke that because I will say whoever had been president earlier in 2020 when COVID hit, I've been certainly critical of President Trump in other speeches, they would have had a really hard time because we divide up authority in such a way, and we made choices over 200 years ago, and we made choices in the past few decades, and then the president made choices, all of which kind of hindered the federal response. And another way to put it, Professor Allison Hoffman and I, we co-taught with another colleague a COVID in the law class last early summer, or 2020 summer. And, I think about the process that the vaccine development and approval is going through right now, which looks dramatically different than it would have 100 years ago when the flu pandemic hit the country. In fact, there wasn't really an FDA back then. Our law of quarantine and masking and state and federal relations looks exactly the same as it did in 2019. There was not a single, a couple nuances I'll mention in a couple minutes, but there really wasn't any legal innovation through the whole 20th century at a time when we were creating big federal agencies over the environment, like the EPA, over labor and employment and anti-discrimination and drug development and medicines and health care financing. We're working with a system of quarantines and masking rules and intergovernmental disputes that's at least 100 years old. In fact, we could go back to the yellow fever epidemic that hit Philadelphia in 1794, when the governor of Pennsylvania was squabbling with the governor of New York about travel bans between the two states. New Jersey was caught in the middle. They sided with New York. But the point is, we really haven't, there was no, we were kind of using the same tools. So the lack of policy innovation frustrates us. What also has frustrated us has been, number one, the Constitution, at least as interpreted by the Supreme Court in the Affordable Care Act case, Sebelius, was perhaps has taken away a key government power over mandating things like masks and vaccines. Number two, though, ever since the New Deal, with lots of big federal authority over commerce, Congress, though it has expanded federal government in so many areas, it really hasn't done much in the public health area. And that frustrated the presidential response. And number three, some of the few tools that President Trump did have, he didn't use. It's not clear President Biden's going to use those either, things like the Defense Production Act. And I guess to sum up this attitude, what's the big thing on kind of preventing COVID in terms of behavioral preventions that President Biden, the big new thing he's going to do, I support it, but it shows how tepid the federal government authority is. He's going to ask Americans to wear a mask for 100 days after inauguration. This is the most powerful leader in the free world, and he's going to ask us to do something that saves hundreds of thousands of lives. That shows you, I think, it's illustrative of the limited federal government authority. Now, why is it so limited? Number one, in the Constitution, federal government only has powers that are so-called enumerated. In this case, the big one is the commerce power, which is pretty darn broad. And through most of the second half of the 20th century, meant any behavior that people did that affected commerce, even if when aggregated, even if I did something very tiny, like have a lemonade stand outside my house, but if that depressed the price of lemonade nationally or spread some other problems, it could be regulated by the national government. And so there's this aggregation principle, but with one big exception that was laid down in 2012 in the Sebelius Affordable Care Act case by a slim majority. Chief Justice Roberts said national government may negate or forbid us from doing certain things. A recent case, even growing one medical marijuana plant in my closet, this is a hypothetical, would violate federal law because if aggregated, it affects the national marijuana market, okay? However, making me buy health insurance, making me wear a mask, that is compelling activity. And in a kind of very formalistic decision that in my mind, it's not supported by any kind of constitutional rationale, because they both dramatically affect commerce. A choice not to wear a mask, of course, when people do that, we see the effect on businesses. When people don't buy health insurance, that affects hospitals and health insurance markets. But the law of the land is that the national government may not mandate activity. What's the big implication that I thought about in 2012? And I thought, it's never really going to happen, is it? A national vaccine mandate, I believe, would be unconstitutional under this line of cases. So it's going to be up to the states. We can talk more in Q&A about how that's going to work in the states. However, think of all the things that affect commerce. So here at the law school, lots of intimate details about the employment relationship and the privacy relationship that we have with employees, faculty members, privacy for students, deeply, minutely regulated by federal law under either the Commerce Clause or the spending power. Not so how we treat COVID, and there's no federal law that kind of would give any federal agency the right to talk about who's wearing masks or not, or how big our classrooms. And we did have students on campus this fall. That was always city law and state law. And so that's because Congress has never taken the breadth of the commerce power that it's used to pass anti-discrimination statutes, sexual harassment statutes, OSHA, workplace safety, et cetera, et cetera, et cetera. They haven't done anything that detailed over the past 100 years with respect to public health. They've left it to the states. That's not a constitutional requirement. That's just a lack of legislation. And then finally, the one area where the Congress through after the Korean War era did give the executive branch substantial authority to fix some of the very problems we have. And with we had a problem early on in COVID. Maybe we'll have it again with the vaccine distribution, with private industry not producing enough masks, tests, et cetera. And there is something right on the books called the Defense Production Act, which was passed with wartime in mind, but applies to domestic emergencies like COVID, that would have empowered President Trump and would empower President Biden, although I don't think he'll use it either, to really direct factories to produce just what we need and alleviate some of those shortages. To this theme, just to show you how under-enforced this idea is, this was, World War II was before the Defense Production Act, but we talk a lot about sacrifices consumers and people are making with COVID, not going home and wearing masks, et cetera. Let me give you something that really jumped out at me when I was teaching this last summer. In 1941, there were 3 million cars produced, new cars produced in the US by domestic factories, 3 million cars. You know, America, we were starting to become a car country. From 1942 to 1944, total production, 150, period. Not 150 million, not 150, 150, period, down from 3 million. That's because the country recognized that the most important thing was not getting a new car, it was fighting and winning World War II. Now, I'm not advocating that dramatic shift, but it shows you, I think, how far we've come as a country in terms of the focused economic efforts that would have been needed, but were rejected by many states, many individuals fighting COVID. Okay, so we can talk more about all these things, but basically this is left things like masking restrictions, gathering restrictions. It's President Biden can't do better than President Trump on that because there's no statute on the books, okay? He could use the Defense Production Act, and he could certainly do better with all the things that Dr. Fleisher is working on and paying for healthcare, as well as just issuing a message about safety and masking. But he doesn't have the authority to dictate schools opening, businesses opening, et cetera. That's for states and governors. Now, one other set of constitutional rules that's very important to all of us is that when any government, even the appropriate one, in this case, the state government, imposes a shutdown order, imposes a masking order, they can't discriminate or they can't violate any of the Constitution's individual rights provisions. And one of those is government shall not interfere with the free exercise of religion. Now, there's baseline law where if something's important enough, you can interfere with religion just like everything else. I would argue this is why I am not as troubled as most centrists, liberals, progressives, as the Supreme Court's opinion, as some of the press reports and others would say, because they didn't single out religion for special protection, in my view. What they said with respect to a New York rule that limited church and synagogue and mosque gatherings to sometimes 10 people, sometimes 25 people, is that's fine. If public health and science dictates that you can't get more than those number of people together, that's fine. This is the court. But you can't only require churches to reach those limits and allow 150 people to go to Home Depot or a sports event or some other secular purpose that is deemed essential, but is kind of a value judgment that going to Home Depot and not imposing strict limits on who gets to walk inside Home Depot, and I'm picking on Home Depot, I could pick on the grocery store, whatever. But basically what the decision said is you got to impose the same rules vis-a-vis essentiality with stores, maybe schools and workplaces, and churches and synagogues and mosques and places of religious observance. And I think the reason it doesn't bother me so much is when I see both in Pennsylvania and New York, the list of businesses deemed essential is really broad. It's not just life-saving medical care, food delivery services. It does include a lot of judgment calls. And the way I read the Constitution's current law on religion is if you're going to make a judgment call about what's important and you're going to include some secular exceptions that are debatable, you've got to let religion have the same exceptions, not a complete blank check, but you can't specifically be lower on religion. I mean, so we can talk more about that in Q&A, but I think it's an important decision, but perhaps not as cataclysmic in terms of the government's ability to regulate, because the next time that something's really important and there's a uniform law that really restricts everything, the government can restrict religion. They just can't make exceptions for non-religious entities and not include them for religious entities.
They pretty much have to start shutting down other pieces of the economy if they want to shut down the kind of the religious, observances.
That's true. Or they'd have to draw a much tighter definition of essentiality and basically mean hospitals, life-saving food, life-saving hospitals. But if you're going to have hair salons, if you're going to have gyms, if you're going to have, I guess you can tell, I don't, although I'm sure I'll disagree with a lot of decisions that maybe this particular majority issues. This one seems reasonable to me because the whole point of the free exercise clause is government is not supposed to say going to a gym is more valuable than going to church. And it's, it can limit the size for all of them, or it has to treat them evenly.
Allison, can I just follow up on one thing that Ted said that was really interesting? Because he talked about you can't mandate masking.
I was going to come back to that too. I'm glad you're going there. Go right ahead.
In nursing homes.
Oh, wait, no. In nursing homes might be a different story. Yeah.
Well, the reason we can has nothing to do with constitutional law. It's actually conditions of participation.
Yeah.
So,
well, that is con law. It's called the spending clause. Yeah.
Yes. Okay. But I was thinking because essentially we said if you want to take our money, you have to follow our rules. And
I'm glad you brought that up because I stated it in too broad. Yes, there's always the ability for particular businesses or entities or, institutions that are on federal grants or that are regulated in a certain way to use it. I think I was referring more to the general.
Yeah, no, I thought it would be for the audience to hear that's the power we used. It was our power of if you're going to participate in Medicare, we can require certain things.
Ted, do you think could that play out more broadly? And Cary, you want to hop in too?
I was just going to say, OSHA also regulates masking in the healthcare settings and has been citing on occasion hospitals for not providing or expecting employees to provide adequate, protective equipment for employees. I also think by extension, OSHA could, it hasn't, but it could go ahead and require a masking mandate for pretty much any workplace. I mean, in theory, OSHA, in a case that the Supreme Court decided in the early 1980s called the benzene case, OSHA can regulate when there is deemed a significant risk, which OSHA typically considers 1 in 1,000 risk. And if you look at the number of fatalities we've had in the US and compare it with our population, we're exceeding that level of significant risk. So in principle, OSHA could require that in all workplaces.
But so this is an important dynamic, though, is that sometimes I think the way we teach constitutional law in law school as well as in high school civics is we assume, and this was the framers' attitude, of course, breaking away from the monarchy, that if you give authority to, you're very distrustful of authority because somebody's going to over abuse it, exercise too much. Well, there is a phenomenon that I think COVID has exposed here and in other countries of national governments not exercising enough muscular clarifying authority and just because they don't want to make the unpopular decisions. I mean, an interesting scholars of Russia, never did we know that, I never knew there were governors in Russia. I thought everything was centralized in Putin's Kremlin, but apparently, the Kremlin was putting out issues. It's all about the governor's choice in Russia, in the different Russian provinces about how to impose shutdown orders, et cetera. So it was an interesting dynamic where people don't want to exercise the authority that maybe they're supposed to.
So when state governors were pushing us to say, we want full visitation rights for Thanksgiving, and we sort of said, are you really sure this is what you want to do? The only authority we had was, are you really sure this is a sound policy? We actually didn't have authority to supersede their authority locally. Because they said this was the right of the resident to go see their family. And we had no recourse.
So that's interesting. That's a case where the federal government is seeing that it doesn't want to step in and it maybe can't step in as well. But, one thing I was wondering about is the dynamic that Cary and Lee are both talking about, Ted, where you have these, you have kind of sub pockets within the administration that arguably could issue a mask mandate in certain settings or based on certain conditions. Do you think that the government could do that more broadly as well? Kind of make it, if you want to do X, Y, or Z, here's your, you have to wear your mask. When you started talking about the way that Biden approached the mask suggestion, I assumed when I heard that was a political move, that wasn't a constraint on authority move. Do you think the constraint on authority is so clear after NFIB versus Sebelius?
Well, yes and no. I think it's clear that he could not say, because a human being walking down the street without a mask could spread COVID and that could affect the economy, that everybody has to wear a mask. I mean, I'm open to disagreement from any of the panelists or any of the audience members because I don't really favor this result, but that's how I read because clearly not buying health insurance, as you know better than anybody on the panel, Allison, affects commerce. And so, however, I mean, I think what you and Cary and Lee have pointed out is there might be a lot more. So Biden could, and Cary, you think about from Reagan forward, when presidents issue through their OMB or other regulatory centralization out of the White House, like every agency that can, whatever its jurisdiction. So for the military, for the nursing homes, for every university that takes federal funding, that they could cover a lot of the population with masks just because the federal, the
CARES Act. Somebody asked us a question.
Oh, well, right. That's a yes.
Fund.
Sure. Actually, that's a great question. But see, it's interesting. It to me, it's kind of telling that there aren't those strings attached, because clearly Congress could have attached those strings to CARES Act. Or frankly, I guess it could attach it to the individual, some of the individual check. If you're going to take this bailout check, or this, you have to participate in our recovery by wearing a mask.
Or getting your vaccine shot. Some people have been suggesting that could be conditioned, a condition of receiving some support. I think it's also, by the way, Ted, I think you're spot on, but it also really emanates much more, I think, than just from Sibelius. It's a larger constitutional culture or constitutional set of conventions or norms. And I think one thing we've certainly learned over the last several years is how important norms are about how we think about the proper way of conducting government. And one norm is simply this history that public health and welfare is first and foremost a state function and not a domain of the federal government. So, there's, I think, a lot of tradition that's standing behind the kind of constraints that you're talking about that explain why we haven't had maybe more robust exercise of federal authority, or might not in any regime, because maybe Congress has never really created the statutory infrastructure to provide that federal oversight and response in these circumstances. Now, I do think there's many, many more things we could have done. I think there was a federal government failure at the very outset and I think it's a failure on the White House's part to be more exercised about the FDA and CDC kind of being slow in a pivotal 3-4 week period of time back in February for approving some alternative ways of testing for COVID. If we had had widespread testing at the outset, we might not be in quite the same dire straits that we are today. We might have been able to get it contained a little bit better, but there were several weeks when the FDA and the CDC, we're operating in their kind of normal mode. Let's get really the best evidence and really go for the perfect kind of test for COVID, when university researchers and others were saying, wait a minute, we've got some other ones, can you give us approval? And they were putting them off. And unfortunately, at the very beginning of an epidemic, time is really of the essence. And we really sort of lost key ground at the very early start of this tragedy that we're all experiencing.
Cary,
But what's interesting, sorry, go ahead.
I was going to say that's helpful, and it helps to answer one of the questions we got in the from the audience, which is pushing back on the notion that the federal government couldn't, could they really not mandate a vaccination? So part of that may just be norms. Legally, we haven't kind of tested. This is a question for you all and for Ted as well. Legally, is it so clear that there would be no authority on which the federal government could issue a vaccination mandate, or is it really more that has just been long a state kind of?
Well, I guess I should. These are helpful, and they're helpful in reining in the absolutism of my language, because because of the authority over employers, and there was Rich Fader asked a good question that but see, they could do that, and indeed, with health insurance, you could say that everybody, the requiring every employer to provide health insurance, as those of you who have worked with benefits know, that is an individual mandate. Because ultimately the employee is paying for that, whether they want the insurance or not. It's just kind of masked as a mandatory compensation. So I think the question about vaccines is important. I do think you'd need this is where we come back to the religious freedom issues. You'd need to have exceptions for people for whom it would be a health risk. And once you do that, you probably need an exception. And a lot of state vaccine mandates have this for people who have a sincere religious objection. Now, as Dr. Fleischer and many of the audience knows better than I, the good news about vaccines is we don't need 100%, on this, because you can get herd immunity from something less than that. I've seen for the COVID vaccine 70%, 75%. So we need substantial uptake, but we could allow some opt-outs. And so I guess it's clear, I mean, and you guys, the questions have made it clear, there's much more the Biden administration could do. Certainly, it has complete authority over the federal government employees itself and federal buildings. And then Congress would have to pass the statute that Rich Fader put in the chat to say, and that would be a big deal, and it would be big debate, and it would raise questions about vaccine objections.
Which, if you think about it, so Penn Medicine mandates as a condition of being a member of the medical staff, taking the flu or with a clear opt-in flu vaccine.
Yeah.
But they're not going to mandate, I'll get my COVID vaccine because I'm still practicing, but they're not going to mandate it right now because there's enough concern that can we right now mandate something like a flu, like the COVID with unknown side effects? And we know that like 50 or more % of the population is not yet ready to take the vaccine. So I think the worst thing they could do is mandate it, with lots of people saying no.
Yeah.
I want to come back to, if I may, a point that Ted made, and I'd reinforce it, that our system of government is not designed for rapid response. And it goes a little bit to the question that's in the Q&A about telehealth authorizations. And, Lee, you may have, knowledge about what the Medicare program allows with telehealth, but it's also, by the way, those requirements for in-person consultations are contained in state licensing requirements for, medical workers and physicians. So at the same time that we might have some change occurring at one level of the government, you need to, often we have what's sometimes called cooperative federalism, but in practice, often it's uncooperative, and it needs to be coordinated. It won't do a whole lot of good to have just one level of government lifting some requirements that physicians see patients in person or prohibiting telehealth if you don't get a coordinated response with other levels of government. And that's just been really challenging too. That's where I think presidential leadership really can make a difference. One thing that presidents can do is they have the power of the bully pulpit. They can bring people together and they can try to help that coordination. And that's really been also something we've been struggling with over the last 9 months.
So 2 good examples. We quickly, CMS, decided to relax the requirement of can you work across state lines, but that doesn't mean that New Jersey will approve physicians immediately in Pennsylvania. Now, the administrator got on, pushed all the states to do a expedited, but it's still the state right of whether or not you're licensed in the other state. The other thing is that 12 days ago, we decided to, I presented to the administrator that we were going to start doing hospital at home, where we, CMS, would pay for you to be admitted to the emergency department, to your home, and we would cover your home and pay for it. And in 7 days, we stood up a program with individual waivers, which I think is pretty fast from the time we proposed it to 5 days ago. We said it's in play as of tonight under our waiver authority. And we have about 10 hospitals who has taken it, but they have to still make sure their state allows them to actually do hospital at home and that we're not violating any state rules. So we can pay for it in Medicare, we can relax our rules, but that doesn't mean the states will follow suit. We're hoping they do.
Lee, part of the question on telehealth was a question about the durability of the changes. That you may not be able to answer this, but I'll put it out there for you. Whether you think telehealth will last in the Medicare program.
You will see that in the physician fee schedule, not the inpatient fee schedule. We did say it would continue for now during the public health emergency. And we're gathering lots of data, and we will have a new administration and a new administrator who will help us decide what we should do. But the administrator has publicly said there are a lot of good parts to telehealth, particularly around rural. But what are the boundaries and where do the beneficiaries get a benefit and where do they not? So those are the questions we're asking. That was a CMS answer.
So, I mean, it's good. It's good. It also means that the data means something, which, you know, we hope that it would, right?
Not that people are happier, but what would be the right way to use telehealth?
Right. Right. So I would love to go back. We got a question earlier that we didn't answer, which probably Cary and Lee, you both have thoughts about this one, which is the good cause exception and notice and comment. What is that, you know, what is not good cause in a pandemic, right? How would you know what is good cause, what is not good cause? And what does it mean procedurally if something is good cause, if it's pandemic related? Are there still procedural constraints, or what is it, you know, are most of those lifted?
Well, most of those are lifted. You can, you know, escape from the need to publish a notice and take comment. What is good cause? Well, you know, at the end of the day, it's whatever the government can successfully justify as good cause. I think in a pandemic, they're going to have the degree of deference. And quite frankly, you know, the government often gets a considerable amount of deference on administrative matters in the federal courts. Not always, and it certainly doesn't mean that the federal government can, you know, just expect to do slipshod work, but if they can make the case for it, you know, I think it's going to be very hard for somebody probably in a pandemic to challenge that justification.
And what I observed, because I talk actually frequently to the general counsel's office too. So the fact that I like the APA and Alina gives me some guidelines, and I do say I have 4 courses in law school, so I'm just dangerous enough. I have been quoted to say to OGC, our general counsel's office, that if we can really document a direct line to COVID response, they will never question us. But if all of a sudden, you know, so the flu was one of those, how important is knowing about the flu? And I had to justify to general counsel that if we can't distinguish between flu and COVID, they use the same resources, and therefore it's COVID related, and I could do an interim final rule. If I asked them to give me measles, you know, or some other condition that didn't use the same resources, they would have pushed back pretty hard. So that's how I experienced it in the agency.
Yeah, it seems to me like that's how the courts would look at it as well, both kind of with some of the administrative questions and constitutional law questions as well, right?
Yeah, I think there's a common theme here that sort of, there's a difference often between what the lawyers' answers or really are, what the law and the books say, for example, versus what the law means in action. At the constitutional level, it's a lot of our culture and conventions and traditions, certainly, that can come into play. You know, and when it comes to getting a good cause exception, the context really matters, and there's certainly going to be a degree of deference to the government during a time of pandemic. And then there's another question in the Q&A about, you know, how binding are interpretive guidelines or guidances? And technically, they aren't binding at all. They can't be binding if they are guidance. If they're binding, then they have to be rules and have to go through the rulemaking process. But what does it mean in practice? In practice, those guidelines are often followed quite extensively. That's what we have. People refer to it. There may be some tort liability, perhaps, that revolves around it, or concerns about that. Or there may be accreditation entities that adopt those guidelines as best practices. You know, so in reality, guidances, while they might not be technically legal, can in practice really have important governance effects.
So the way we use them, is that okay, Allison?
Please, yes, and then I'm going to turn us to wrap up because we have 5 minutes left.
Okay. So the way we use them is for survey and certification, which is a little bit of what Ron's question was around. If we can tie it back to a reg, and all we're doing is saying how the surveyor should interpret the reg, we usually get away with deference, complete deference. If we can't point it back to that reg, we usually know we're in some degree of trouble. And talking about lawyers, we get for some of these, I'll get anything from we concur with your decision to move forward to we don't concur and therefore we can't do it to we're going to be silent, which is that, you know, we are going to let the policymakers say what we should do. So they'll defer, they'll be, if I pick up the phone and say, I need this, and I've done this recently with OGC, and they say, we're not going to non-concur, this may be challenged after, but we are going to defer that you will be able to explain why this was critical during the pandemic.
Right. I think government lawyers often speak in terms of litigation risk, and they want to let you know, the decision makers, what the litigation risk might be. And at the end of the day, if it seems like you need to go forward, even to take some litigation risk, at least you're informed about that.
Yes.
Yeah.
So now that we've made clear to the audience that the boundaries of the law, they are there, they are fuzzy. I have one last speed round question for you all. We have 3 minutes until the end of the event. So I'm going to ask you, you know, when we look at where we are today, we're having 200,000 new cases a day, hospitalization levels are reaching highs. And, you know, a number of other countries are in a similar position, but some countries around the globe have contained the pandemic at this point. If there's one thing, if you could rewind back to January 2020, or maybe even a little bit before that, if there's one thing you could tell regulators to do differently, what would you tell them to do? Let's go in reverse order. So Ted, I'll start with you.
I mean, the most radical thing would have, well, there's two things. One is actually goes to the connection between law and scientific expertise. I wish that every level of government had acted in terms of severe shutdown. Even I would take 1 week early. Okay, so, and this is New York City, New York State, the national government had really shut down hard. March 3rd instead of 10th or whatever. No, it would have been even March 7th instead of March 15th. And I've seen some modeling that shows, and then I would have, I mean, I'm not a politician, so I can say this, the most dramatic thing that would help next time is significant restrictions on internal travel, just like we imposed restrictions on external travel, but, you know, really not letting people travel much interstate at all. And again, no politician at any level was willing to do that.
Cary, what is your one thing?
I guess this isn't really the kind of answer you might expect from a law professor, because it's not really law. I would say it's resources. And that's across a whole gamut. Testing resources, we should have been on that right away. We could still really expand our testing resources. PPE resources, not only for people in the healthcare setting, but, you know, South Korea worked to make masks available to the public for mere pennies each. We should have that kind of capacity built up for those kind of resources. And then, of course, resources for the people who are struggling with this, whether it's the small businesses or the people who are out of work and likely to be out of work for some time still. So we do need to provide more resources.
And that's still the case. I mean, that's still an issue and will continue to be.
Yeah.
Lee, last thoughts.
You're making it impossible for me to answer the question, but I will say, because I live in an agency that has a limited scope and went way outside its scope, and I'm actually very proud of what the agency has done since the beginning. But the thing that I'm most concerned about, maybe a little differently, and it's ongoing, is hospital capacity and the resiliency of the workforce, hospitals, nursing homes, and our essential workers. They're getting tired. And if there's anything we can do to shore that up, because we still have a long winter ahead, as they say. So I'd actually say figuring that out right now is a high priority.
Yeah. Great. Well, thank you all. This has been, for me, has been a very interesting panel. It's been a pleasure to moderate it today. I want to thank everybody in the audience for joining us and apologize if we didn't get to some of your questions, and also to thank Kathy and the ML program for organizing today's event. So thank you all for being here, and I wish you a great evening.
Thank you, Allison.
Thank you.
Thanks.
Welcome.
Tremendous thanks to all of you. Thanks very much.